Hi there, this is Jonathan Ginsberg. I'd like to talk to you today about what happens if you're in Chapter 13, you're a debtor in a Chapter 13 case, and your family situation falls apart a little bit, and you end up filing for divorce or becoming a defendant in a divorce proceeding, and your whole budget changes, your household changes, now there are two households, you don't have your spouse's income, all that type of stuff. And obviously, just as an overview, Chapter 13 is really designed for stability, so it's definitely a problem if you find yourself with a big change in your budget when you go into Chapter 13, because your plan was no doubt designed based on a set series of numbers, your income, your expenses, and now that's all changed. Well, the first thing you need to do is you got to talk to your bankruptcy lawyer. Let them know as quickly as possible something's going on, because it's much better to be in front of these type of things and be proactive. And the type of things that I do, I have done. One would be you can ask the court for a 2 or 3 month deferment in payment obligations, so you can buy yourself a little bit of time to kind of get back on your feet. If that means you have to get into an apartment or you have to assume certain obligations that you didn't otherwise have, you may need a little time to kind of get back on your feet. The second thing is you need to get new budget numbers, and I realize that these things can change, but if at all possible, what you want to do is you want to look at the budget you filed and then redo that and come up with as clear numbers as you possibly can. Because what you can do is you can file a post-confirmation, which is that when the case is approved, a post-confirmation amendment to your Chapter 13 that reduces your Chapter 13 plan payment to reflect the new reality of your situation. And it could be reducing the plan payment, it could be reducing the percentage debt to unsecured creditors, or the debt repayment to unsecured creditors, any of those things. You may need to go to a hearing in front of the judge, but if you can document that you have less money coming in, that you have increased expenses or different expenses, but you're doing the best that you can given your new reality, usually the judge will be pretty amenable to making that change. Now again, all creditors are going to get served with this, so your soon-to-be ex-spouse or ex-spouse may be a creditor and will get served with this as well, so you may get some pushback from your ex-spouse or other creditors, especially if changing your plan negatively affects your soon-to-be or ex-spouse. But nevertheless, you've got to do what's best for you. So I've had a number of these cases over the years, and again, as long as I have real numbers, not just what we think may be or what we hope may be, but real numbers, we can either A, buy some time at the outset, and B, we can go ahead and file an amendment to change the plan to reflect the new reality. And my experience has been that judges will be receptive as long as you are doing the best that you can. Now realize that Chapter 13 in general, the trustees are going to want to see every dime that they can that is disposable. When you go through a budget change, especially if you're reducing your payment, they're going to really want to see documentation. So that means you want to save your receipts for things like groceries and utilities, things like that, to show that you are in fact paying all these things. If you're alleging that you're paying child support or alimony, you're going to have proof and copies of canceled checks, proof that you actually made these payments. Because the bankruptcy court, for some reason, is very, very concerned about you not making payments on alimony and child support. Again, not that they shouldn't be concerned about it, but it seems to be it's not really a bankruptcy issue, it's more of a domestic relations issue. But nevertheless, the court's going to want you to document that you're making these payments and to verify with some various forms that in fact you have. So you want to keep records. I think that's really another big thing, is keep records of all the things you're doing. But if you do that, and you deal with your attorney quickly, and you come clean with all the information, and you make sure it's very clear, usually we can go ahead and get your plan adjusted to make it something that is feasible given your new reality. And again, that may be going in front of the judge, it may be negotiating with the trustee, but all these things can be done to make your case viable and to keep you in bankruptcy so that you don't lose the benefit of what you've worked hard to achieve in terms of your plan, and that you get the benefit of the bankruptcy discharge when it does come along. So I hope this has been helpful. Again, Jonathan Ginsberg here, Ginsberg Law Offices in Atlanta, Georgia. Any questions, please let me know. Thanks a lot.